Good evening, everybody, and welcome to the second Crone Law Firm Facebook Live show. My name is Alan Crone. I'm the managing member and founder of the Crone Law Firm. We're located in Memphis, Tennessee, and we're an employment law firm representing employees, executives, and entrepreneurs in legal disputes and issues that affect their ability to make money. And we had a very successful broadcast a couple of weeks ago, and thank you for everybody who's commented and emailed us about various aspects of that show. And we're hoping today that our show today will be very helpful for everyone as well. Our topic today is a topic that we frequently receive calls about here at the firm, whether they're informal calls asking a question or being hired to help people either enforce or defend themselves against a non-competition agreement or some other agreement that restricts their ability to compete in the marketplace. And these are tools that are being increasingly used out there, both in terms of the employment-employer relationship, and they're frequently an agreement that's part of either the sale of a business or the acquisition of a business, or sometimes business partners will have non-compete agreements in the event that the business dissolves or one of the partners leave. So we're frequently asked about these situations, and so we wanted to do a broadcast on them and talk about them a little bit more in depth. So the first question is, what is a non-competition agreement? And that's a complex question because non-competition agreements are complex and they come in a lot of varieties. And oftentimes an agreement will say it's a non-compete agreement, but when you read the text of it, it's not quite as restrictive as you might think by labeling it as a non-compete agreement. So the first provision that is the most restrictive is a full-on non-compete, which means that the worker who works for company A cannot go out and compete in the marketplace if they start their own business or they go work for company B. For example, you have a shoe salesman who sells shoes for company A and has a book of business of places, maybe he wholesales shoes and sells to a bunch of businesses in Memphis. And a non-compete agreement would say, okay, Mr. Worker, you can't sell shoes to anybody in the city of Memphis for a period of time. And that's a non-compete agreement. Now, another form of non-compete agreement is what they call non-solicitation agreement, where you can't solicit the customers of company A if you leave the employment of company A. So in that circumstance, I might have 5 shoe stores in the city that I've sold shoes to, and a non-solicit agreement would say, I can't go and do business with those 5 stores for a period of time. But I'm free to go and call on other businesses that I haven't done business with before. I'm allowed to compete, I'm just not allowed to solicit those customers. Another form of restriction may be a restriction on the use of confidential, proprietary, or secret information. And that sometimes will be a separate clause, or it might be a justification for the non-compete or non-solicit clause. And that restricts the worker's ability to use certain information in competition in another employment setting. And when those two things come together, it can be a real problem for finding subsequent employment or starting your own business, and frankly becomes a real hurdle in moving on to that next employer, at least within that industry. So none of these would, for example, preclude that particular salesperson from going and selling ties to those stores or selling ties to someone else, even if there's a non-compete agreement, provided that the company A doesn't sell ties, it only sells shoes. So each agreement, you have to review it very carefully, and you have to review it for the particular circumstance at hand. It's not a one size fit all, and that's why it can be very, very complex. And the first question most people tend to ask me is, well, is this non-compete agreement that I have enforceable? I own a business and my employees have non-compete agreements with me. Can I enforce it against them? Or, Mr. Crone, I've left employment of company A, and I've got this non-compete agreement that I signed when I first went to work there, and is it enforceable? And I'll give you a good lawyer's answer. It depends. It depends on a lot of factors. Frequently, on the business side, people say, well, I hear these things aren't worth the paper they're written on. Why even have them? And my response is, from a company standpoint, these agreements are very valuable because they exist. And it's something that a employee has to consider when they're thinking about leaving to go start their own business or to go work for someone else. They have this non-compete, and in the latter instance where they're going to work for another company, they have to tell company B, hey, I have this non-compete. And sometimes company B says, look, I don't want to hire a lawsuit, so I'm going to go hire somebody else who doesn't have a non-compete. Or if I'm someone who's thinking about starting my own business, I have to take into consideration the fact that I may be restricted in some way in starting that business. So it can be a very valuable tool for businesses. And if you're a business and you want to have one, you need to be very careful in how you draft them. And if you're an employee going into a new employment relationship and that company presents you with a non-compete, you can't just blow it off and say, oh, I signed this. It's not enforceable. They are enforceable. However, both in Tennessee and in many other states, non-compete agreements, the court can alter them by changing provisions to make them fair if the overall agreement is not fair. So what are the considerations the court is going to look to determine whether or not one of these agreements is enforceable? First thing they're going to look at is, what is the compelling business interest that the company has in enforcing the agreement? And if they can't articulate one, if they can't say, well, having this person go work for themselves or go to work for someone else will give them a competitive advantage because of their previous relationship with me, that's going to be a very difficult enforcement action because one of the elements is the company has to prove that there's a compelling business interest. Frequently, drafters will put into those agreements, all the parties agree that there's a compelling business interest. Frequently, judges say, I understand it, that's great. Well, articulate what that business interest is for me. I want to hear it. And no matter what the agreement says, the judge will refuse to enforce it if the company can't come up with what that compelling business interest is. That compelling business interest could be relationships. In other words, this person has a relationship with all my customers that they have developed on my nickel. I've been paying them to develop these relationships, and it's not fair for them to leverage those relationships. It may be training or other proprietary or confidential information that the employee is given. Say this person has access to all this training that I paid for, and I don't want them going out and competing against me for that reason. So that's a consideration. Another consideration is, why did the employee leave? If the employee left on their own to go pursue competition, court's going to look at that more severely than if the employee was fired for poor performance or as a reduction in force or for no reason at all. And in those circumstances, generally, it's been my experience that the judges will require more of the employer, the former employer, almost saying, well, if they're such a bad employee, why do you care if they can go compete against you? Conversely, judges don't like it when someone tries to take a bunch of information or a bunch of relationships that they built up and go out and submarine the former employee and former employer in the face of a non-compete. So why the employee left is usually a big bone of contention. Also, the duration. Is this 6 months non-compete? Is it a year? Is it 2 years, 5 years? I've never seen one for longer than 5 years. I have seen agreements for 5 years. They're rarely enforced for 5 years. It's usually somewhere in the 2 to 3 year area, and frequently judges are saying, well, there's really not much reason for it to go more than a year. Again, it depends on what the compelling business interests are, and oftentimes the economic or financial conditions that might justify a non-compete or non-solicitation exist for a year or two, but really after 3 or 4 years, those considerations don't exist anymore. It may be a pricing structure or market conditions that were being taken advantage of that change, or marketing plans change, or business plans change. And so it's very hard to justify enforcing these for more than a year or two, although it can be done. And that goes back to the employer understanding what the compelling business interests at stake are. And so in an enforcement situation, we look at that very, very heavily. Also, courts are going to be persuaded by how much damage the former employer can do to the employer. Is it material to the existence of Company A to have this agreement enforced? So there are lots and lots of variables that depend. And finally, I'll talk about geographic scope. And sometimes geographic scope is very, very important. Sometimes there are licensing requirements. You know, the company might, the employee might need to have a license in Tennessee to provide a certain service. And so practicing in Tennessee versus Arkansas versus Mississippi or other states, that might be material. Sometimes it's, well, what's the applicable market? And sometimes the market can be a very small geographic area because expert witnesses will say, well, most of the customers of this company only come from 2 miles away or come from just the county in which it's located. Sometimes, like the Tennessee walk-in horse business, the geographic scope is worldwide because there's a limited number of people who are in that market, and they're located all over the world. So sometimes geography is very, very important, and sometimes it's not important at all. So that's another factor to consider. And just as the courts can with other terms, the courts can also readjust that geographic scope if it's equitable to do that. Many times people ask me, all right, well, what's the procedure? What happens? How do I get out of a non-compete agreement? Why should I hire a lawyer to help me with that? Well, the first reason is these are economic, financial considerations. When I'm on the enforcement side of these situations, one of the first things I ask the client is, all right, how badly is this guy going to hurt you? How badly is this woman going to hurt you? And if not, you've got to really consider the cost of enforcement versus the value that you're going to get. Sometimes the value is just in making sure that people know that you're going to enforce the agreement, and that can have a very, very high value that's hard to quantify. Second of all, when you're trying to defend against these, you want to try to negotiate with the other side and see if there's some restrictions that you can live with that benefit the employer to the extent where they will agree to modify the terms of the agreement. And that's done by the lawyer understanding the compelling business interests involved, understanding both the background of the company, the background of the employee, and understanding how what you want to do going forward will affect the enforcing company. And so after having long conversations about all of that with the client, a lawyer can advise you on what kind of deal can be struck. If you can't work out this situation with the enforcing company, then you may have to litigate it. And that is a big consideration for a lot of people. You have to really consider, all right, this new job, this new venture that I want to go into, is it worth the cost of defending a lawsuit or bringing a lawsuit for declaratory judgment, in other words, going to the court ahead of time and saying, I want to compete and I want the court to tell me that my agreement doesn't preclude me from competing, you have to make sure that that's cost justified. And if it is, if you have a valuable opportunity, then you want to probe very carefully that compelling business interest. If you're enforcing, you want to establish that compelling business interest with copious evidence. And if you're defending, you want to show that whatever the compelling business interest is not really all that compelling, and that there's no equity in enforcing the agreement. And the way I usually try to frame that debate is in unfair competition. If I'm on the enforcement side, I want to tell the judge, look, Your Honor, it's unfair for this worker to go work for company B or to set up their own company because they're going to have an unfair competitive advantage because of their previous relationship with my client. Conversely, if I'm in a defense standpoint, I want to look for ways that I can argue, look, we don't have an unfair competitive advantage. And frequently, it turns on whether they're going to be able to compete globally or whether they just can be restricted from certain customers. And frequently, that is or maybe specific service lines or products that were involved. And so you can frequently work these things out if both sides are willing to really put their business hats on and look at it from a dollars and cents standpoint, rather than just getting all worked up about everything that led up to the departure, which oftentimes is very, very relevant from a litigation standpoint, but may not be relevant in terms of everybody getting on with their lives and not spending their times in depositions and in courtrooms. And so let's kind of take those two things separate. Let's talk about enforcement, and then let's talk about defense. How do I enforce a non-compete agreement? Well, the first thing that a lawyer is going to do is contact the other side and remind them of their obligations. If you know that the employee is starting their own business, or if you know that they're interviewing for a particular job or been hired by a particular company, you want to put everybody on notice that, hey, this employment agreement exists, it has a restriction, and we intend to enforce that agreement. Frequently, you can resolve it at that point. You engage everybody in negotiations, and you tell them, look, we're going to enforce this agreement. And frequently, everyone says, well, we don't want a lawsuit. We don't want this expense and trouble, so we're going to back off of this. That's why I say the existence of the agreement makes it very, very valuable. If the conduct persists, then you want to look at an enforcement proceeding, and you want to make sure that you have all of your ducks in a row. I recommend engaging an investigator to interview witnesses to really determine exactly what is going on, because frequently you're operating in the fog of war. My client gets reports that after employee A, let's call him Mr. Adam leaves the employment, and you hear vaguely he's working for company B. And now all of a sudden we start to lose customers. And some of them have relationships with Mr. Adam, some of them don't. And everyone begins to think, well, this is all because Mr. Adam is soliciting customers. Well, you want to start making some inquiries. You want to find out what's really going on, because you're going to have to prove not just that the agreement exists, but that he's violating it. And that can be tough to do, because you have to involve customers and former customers in that conversation. And sometimes clients don't want to do that. So you've got to think through that. You've got to understand what the person is doing and who they're doing it with. Once you do that, you put your complaint together, you file it in court, and then you're going to go to a hearing on an injunction. In other words, have a court order the worker to stop doing whatever it is that they're doing. And that hearing is going to be very, very important. Frequently, the defendant will want to conduct discovery, or you may want to conduct discovery, do depositions. Depositions are a question and answer session with a lawyer under oath with a stenographer who takes down everything that's said. It creates a record. You may want to subpoena documents from the other side, and you really want to be prepared for that first hearing in front of the judge on what we call a preliminary injunction, almost as if this is the trial, because frequently it all gets resolved at this stage because that's when everybody kind of figures out what's going on. And so once you begin that process, it starts rolling down the hill. It can be tough to reverse it. So you've got to be prepared for the long haul when you're enforcing an agreement like this. I also always advise clients not to look for money. If there are money damages, you want to pursue those money damages, but your first primary goal in an enforcement proceeding is to stop the offending behavior. And once you stop the offending behavior, then you can assess whether or not you really need to continue after money damages. And the longer the conduct persists, the longer the case goes, frequently the more damages that are incurred. And both sides have to take that into consideration as the case moves forward. What do I do to defend myself against a non-compete agreement? Well, I think you can take a lot of lessons from the enforcement side. The first thing is to hold the enforcing company to the letter of the law and to make sure that everybody understands what this compelling business interest is. Frequently, I have found you can really investigate whether there's competition or not. In today's economy, operating within the same industry, frequently you're not really competing against the other company because you may be going to work for somebody that has different services entirely than company A. And what I always ask clients is, well, can people do business with company B and company A at the same time? And does it make financial sense to do so? So the first thing you want to look at is, am I really competing against company A or not? And then as we go through this, you don't want to go down this road unless it makes monetary sense to spend the time and the money to fight it. And sometimes you're just better off trying to make a deal without incurring expenses. I have found that frequently both sides at some point come to the realization that continued litigation does not make financial sense for either one. And that's when everybody sits down at a table in a mediation or in some sort of settlement conference, either in person or over the phone, and tries to work something out. Because oftentimes, I would say almost 99% of the time, there's a business solution to these issues that's best arrived at among the parties rather than forcing a judge to decide. Because frequently a judge's decision, when you apply the law to a specific situation, oftentimes neither side is really all that happy about it. I can tell you that I've had a lot of experience. My law firm has had a lot of experience with these kinds of cases. I've literally litigated these cases all over the country. I've had non-compete cases in Oregon, in Ohio, in Oklahoma, in Memphis, Mississippi, Arkansas, Florida, Alabama, and the issues are always very, very similar. And almost always, it comes down to these business decisions that clients have to make about the cost of continuing to go forward versus the benefit of getting their way, whichever one it is. I hope this has been helpful. We've just kind of scratched the surface of non-competes. I'm sure in future shows we will maybe drill down a little bit farther on them. If you have any more questions, please feel free to email us at the Crone Law Firm. Our email address, our website is cronelawfirmplc.com. That's cronelawfirmplc.com. Or you can reach us here at 901-737-7740. That's 901-737-7740. and we'd be happy to interview you and see if there's something we can do to either answer your question or to help you with your non-compete issue. I've enjoyed speaking with you. I hope that y'all have a great St. Patrick's Day weekend. We're recording this on March 16th, and look forward to seeing you next time. Thank you.